Hello and welcome to Barcast Audio. This is our module on anatomy of an essay question. In this module, we're going to break down an impeachment evidence essay question. We're going to walk you through how to pull the facts of an essay question out and apply them in a way that will maximize your points. In this module, we're going to read a real bar exam essay question, and we're going to talk about which facts are important and why. We're going to talk about how the facts of the question can tell us immediately what's being tested. And once we get there, we're going to talk about how we can connect those facts to our rule statements in a way that can maximize our points for the bar exam. So enough talking from me. Without further ado, let's get started. There's going to be an essay question on the bar exam that is going to feel like a gut punch. You're going to read the question, scan for issues, and realize suddenly that you have zero idea what the question is actually asking. The sooner you realize this, the better off you will be. Many of you will enter the bar exam with predictions for what will be on the essay section. I did it. Many of you will do it. Many of you will be right. But I can guarantee you that nothing, no prediction, no website can prepare you for a Civ Pro, family law, crossover on issue preclusion, Erie doctrine, and common law marriage. There are just curveball questions. They don't go away. They're always there. When I took the July 2019 UBE in New York, I came into day one relatively confident. Not only had I been smoking every practice essay question going into the exam, but I also felt I could rely on the predictions that I had read online. And you know what? I kind of could. Fast forward 2.5 hours later. I had just finished my fifth essay and I was feeling good with a capital G. The prediction that I had read had actually nailed it. 4 of the 5 essays had been on their list. So when I flipped to my 6th and final essay to see the predictors were right yet again, I was over the moon. It was a Civ Pro question, and I knew Civ Pro. I felt like I had committed myself to knowing every which way it could be tested on the exam. Which is why, as I was reading the question and slowly realized that I had no idea what in the hell I was being asked, I felt my blood run cold. I was screwed. I stared down at the keyboard for what seemed like an eternity, looked back at the question, almost trying to will it into something familiar, something comprehensible, and it didn't work. I looked up over my laptop, desperately looking for a sign that anyone else there was having as hard of a time as I was. Fortunately, I saw people all over looking exactly like I did. They had gotten punched in the face too. What I did next was what saved my bar exam. I looked back at the question and got to work spitting out what I hoped and prayed would be a semi-decent answer that could at least allow me to pass on the strength of my other answers. And it worked. I passed. I scored well in the essay section. I got to be a lawyer. Yay. But what saved me wasn't any plan that I had going into the exam. What saved me was the instincts I had built up during bar prep. In the end, those instincts are all you have to fall back on. And you build them up now in bar prep by doing stuff like this, by writing out essay questions, by outlining them. And the point of this module here is to help you develop those instincts. So let's get started. First off, going into any evidence essay, you should have a table of contents in your mind that you can use to check off any subtopics being tested as you're going through the facts. Is this hearsay, impeachment, character evidence, privileges? It's important that you develop rule statements for each of these topics that you can easily spit out the moment you realize it's being tested. For hearsay, for example, the moment you see it's hearsay, you should be thinking, my first rule statement sentence is, a hearsay statement is an out-of-court statement that is offered for the truth of the matter asserted. Hearsay statements are generally inadmissible unless an exception applies. From there, you would go through your exceptions and see which one did actually apply. The facts will guide you as to what is being tested. Once you realize the topic, run through all the sub-rules in that topic. For hearsay, that's exclusions and exceptions. Remember Dead Fred and Peter Pan? You'll need to have these rule statements down cold so that they become almost second nature. Because like I said, it's all about building instincts when you go blank, when you're looking at a question and you don't know what's going on. The best test of this is when you can scan a fact pattern and immediately have a fact jump out to you as indicative of a certain rule. Let's run through a sample MEE essay question to get a feel for how we should be attacking these evidence essays. We're looking at the July 2014 MEE questions. Evidence. You can access these on the ncbex.org website. I'll read the question. A prison inmate has filed a civil rights lawsuit against a guard at the prison, alleging that the guard violated the inmate's constitutional rights during an altercation. The inmate and the guard are the only witnesses to this altercation. They have provided contradictory reports about what occurred. The trial will be before a jury. The inmate plans to testify at trial. The guard's counsel has moved for leave to impeach the inmate with the following. A. 12 years ago, the inmate was convicted of felony distribution of marijuana. He served a 3-year prison sentence, which immediately began after he was convicted. He served his full sentence and was released from prison 9 years ago. B. 8 years ago, the inmate pleaded guilty to perjury, a misdemeanor punishable by up to 1 year in jail. He paid a $5,000 fine. 7 years ago, the inmate was convicted of felony sexual assault of a child and is currently serving a 10-year prison sentence for the crime. The victim was the inmate's daughter, who was 13 years old at the time of the assault. The inmate's counsel objects to the admission of any evidence related to these 3 convictions, and to any cross-examination based on this evidence. The guard also plans to testify at trial. The inmate's counsel has moved for leave to impeach the guard with the following. Last year, the guard applied for a promotion to prison supervisor. The guard submitted a resume to the state that indicated that he had been awarded a BA in criminal justice from a local college. An official copy of the guard's academic transcript from the college indicates that the guard dropped out after the first semester and did not actually receive a degree. The guard's counsel objects to the admission of this evidence and to any cross-examination based on this evidence. The transcript and the resume have been properly authenticated. The trial will be held in a jurisdiction that has adopted all of the federal rules of evidence. 1. What evidence, if any, proffered by the guard to impeach the inmate should be admitted? Explain. 2. What evidence, if any, proffered by the inmate to impeach the guard should be admitted? Explain. So now that we've read through the question, I want you to think about which facts jumped out to you. The answer should be fairly obvious, but if you can't name them, don't be too hard on yourself. I'll give you a few seconds to think, and in that time you should feel free to rewind and listen to the question again. Okay, here goes. If you read through this question, the first fact that should have jumped out to you was the statement, the guard's counsel has moved for leave to impeach the inmate with the following. This statement seems to straight up tell us that this is an impeachment question, but we still have to read on to make sure. Next come our 3 highlighted means of impeachment. First, plaintiff's conviction from 12 years ago. Second, plaintiff's conviction from 8 years ago. And third, plaintiff's conviction from 7 years ago. By now you should know exactly what's being tested. Let's think mechanically about this. So first, we see that it's an impeachment question. So our logical next step is to think of the 7 most common methods of impeachment. Remember Ivan the pretty damn bad cop, who screwed up the prosecution's case by getting impeached by all 7 of the most common 7 methods of impeachment. The 3 facts I've mentioned make it clear that we're being tested on impeachment by prior convictions. But let's shelf that for a second and focus on what issues present themselves in the second half of the hypo. The second half of the hypo seemingly presents us only with one fact of note. I'm talking about the fact that the guard lied on his promotion application about graduating college. But this is kind of misleading, because this final fact actually invokes 2 issues. First, that the guard can be cross-examined about his lying on the application. And second, that if the guard denies lying, that the resume and application can be authenticated and admitted as extrinsic evidence. Let me just say, if you missed that second issue, don't feel bad. I missed it the first and I think the second time I did this essay myself. But just note that its presence is an opportunity for you to rack up even more points on this thing. That's the kind of issue that could take an essay from a 5 to a 6 if you're using some UBE score or MEE score. So now we've read through our essay and identified each of the pertinent facts. Now let's go through each fact and talk about what rule it invokes. First, the inmate's conviction from 12 years ago. This fact is clearly testing us on the 10-year window for impeachment by evidence of felonies which are not crimes of dishonesty. Note that evidence of felonies that do not involve a crime of dishonesty are relevant in civil cases where the witness is not a defendant and in criminal cases where the witness is a defendant and the probative value of the evidence would not be substantially outweighed by its prejudicial effect. This is a civil case, and the crime of selling marijuana is not a crime of dishonesty. So evidence of this crime would theoretically be allowed to impeach the witness, unless its probative value was substantially outweighed by a danger of unfair prejudice or some other Rule 403 concern. Note that if more than 10 years have passed since the later of a victim's conviction or release, an alternative balancing test applies. Under this test, evidence of a conviction from more than 10 years ago is only admissible if reasonable written notice is given to an adverse party and its probative value substantially outweighs its prejudicial effect. Here, the facts of the question are attempting to trick us. Although the inmate was convicted 12 years ago, which is obviously more than 10 years ago, the alternative balancing test applies to the later of his conviction or release. Because he was released 9 years ago, this balancing test would not apply, and the inmate could be impeached by evidence of this conviction. Let's move on to issue 2, inmate's prior conviction for perjury. This is testing us on the rule for impeachment by prior crimes of dishonesty. This rule is simple. Felonies and misdemeanors involving crimes of dishonesty are always admissible to impeach a witness. So the answer here is simple. Inmate would be impeached by this conviction. This brings us to issue 3, inmate's sexual assault conviction. Again, this is testing us on the rule for impeachment by felonies that do not involve a crime of dishonesty, just like issue 1. Here again, we should apply the civil versus criminal distinction that we talked about in issue 1. Under these facts, the inmate is not a defendant in a civil case, but in fact a plaintiff. So this conviction could therefore be admissible to impeach him, unless its probative value was substantially outweighed by its prejudicial effect. And here, I think it would be. It seems unlikely that the evidence of a prior sexual assault conviction would be probative of anything of value to the inmate's altercation with a prison guard, and admitting this evidence would immediately prejudice any jury against the inmate. Thus, this evidence would likely be excluded. Let's talk about issue 4, guard's falsified info on his promotion application. This fact is testing us on impeachment by prior bad acts. The rule for prior bad acts is that a witness may be cross-examined as to any prior bad acts only if the conduct is probative of the witness's character for truthfulness. Guard is being crossed on whether he falsified documents, which would clearly be probative of his character for truthfulness. Thus, inmate's attorney would be allowed to cross him on this issue. Finally, this brings us to issue 5. Can the guard's resume and application be admitted as extrinsic evidence? The answer is rather simple, no. While cross-examination as to evidence of prior bad acts is allowed, the court has no discretion in allowing extrinsic evidence to prove prior bad acts. If the guard says on the stand that he never lied about having falsified any information in his promotion application, inmate's attorney can't simply offer extrinsic evidence into evidence to prove that the guard did in fact lie. He simply has to accept the guard's answer for what it is. This has been a basic breakdown of all the rules being tested and how the facts of the hypo apply. Now, the unfortunate reality is that knowing this isn't enough. You have to take those rules and facts and organize them in a way that the bar examiners like. And to do that, the best advice I can give you is to think about it like you're explaining impeachment to a 6-year-old child. I know, it's borderline child cruelty just to even think about it. But you really have to break everything down to the micro level. The key is to write a beefy rule statement paragraph. You should have these almost pre-written in your head going into the test. And you will by the time exam day comes. But if you do that, you can simply pull the relevant facts and connect them to your rule statements and draw a relevant conclusion. Ultimately, your conclusion is a whole lot less important than the way in which you use the facts presented to you. Remember that even if you forget the third element of a rule statement, you can just make it up. As long as you're accurately applying the facts, you're going to get some points out of it. The most important thing you can do on the bar exam with these essays is to connect the facts to the law. And the law doesn't have to be perfect, and your conclusion doesn't have to be perfect. So as long as you have the rule statements down pat, you'll be able to look at a fact and realize what it's testing. And once you get there, you're off and ready. This has been the first of our Anatomy of an Essay modules. Let me know if you'd like to see more of these in the future. You can contact me at barcastaudio.com or by email at doc@barcastaudio.com. That's doc, like DOC, at barcastaudio.com. Thanks as always for listening, and I'll talk to you soon. Bye now.